I think that training was helpful. How do we get that back now? The state presented evidence of violations of Iowa Code Chapter 714.16, also known as the Consumer Fraud Act, through the testimony of witnesses from the Food and Drug Administration, Iowa Department of Agriculture and Land Stewardship, and the Iowa Attorney General's Office, period. At the conclusion of the preliminary injunction hearing, the court entered an order stating its findings and granting preliminary injunctive relief, further enjoining all defendants from any further activity of any kind or nature associated with the marketing of any pet medicines or foods, period. The preliminary injunction was personally served on the defendants, period. New paragraph. An application and order setting final hearing in this matter for January 31st, 2003 at 1:30 p.m. was filed November 18th, 2002. That hearing was subsequently continued to February 13th, 2003 at 9:30 a.m. 9 being a judgment, 30 being the blood of Christ. We're looking for someone to crucify to make this matter go away. New paragraph. No written answer to the state's petition was filed on behalf of any defendants. Dishonor? Yes, unless there was a private process going on in the background, which part of the time there was. Defendant B did submit to the clerk of court for filing multi-page documents on January 21st, 2003, and again on February 10th, 2003, which are each captioned as Notice of Agreement. Neither is a responsive pleading. Notice her first filing was on the date that they canceled that first hearing. So obviously what she did was a response. Whether or not she carried through properly is what we're looking at with regard to these proceedings. Why did the court hold her in contempt? This order is an older document from March of 2003, and it's part of the paperwork that points toward the hearing which took place, I believe, in May 2003, which created the condition of jail for the contempt. So this document leads up to the conditions creating the contempt. The document goes on. Each of these filings appear to be nothing more than photocopies of documents served upon Defendant B or sent to her by the state's counsel in an effort to settle these proceedings prior to trial. What did the court say the Iowa State Attorney General was trying to do? Settle the case. Privately. What was Defendant B allegedly doing according to these documents? Not helping to settle. On the date of trial, Defendant B presented to the clerk two single-page documents which are styled surety bond. What did Defendant B try to do? Come in and bond the case to be the creditor. That in and of itself is not a dishonor. That in and of itself is not a bad practice, but it is not sufficient. If you're going to be the creditor, you have to resolve the problem, not just say, I'm going to be creditor. The document goes on. At hearing on February 13, 2003, the state presented the testimony of Defendant B, Defendant A, and another gentleman who was an investigator with the Iowa Attorney General's office. The court also took judicial notice of the transcript of the evidentiary hearing on June 6, 2003. That must be a typo. It's got to be 2002 because this document was signed in March of 2002. Yeah, you're right, Caleb. Harmless error. You're catching on to this. This is cool. Another thing to argue and become dishonorable about. New paragraph. Of particular importance is the testimony of witness Defendant B. Isn't Defendant B the woman that was in jail on contempt? Who brought the evidence of her testimony to the court? No, she didn't bring that. State Attorney General brought her testimony. Number one, what in the world is she doing testifying? If she is testifying to the merits of the case, she is the debtor in fact, which explains everything that's going on here. Remember, anything you say, well, let's just put it this way. Everything you say, unless it's a negative averment, is a confession used against you, no matter what you said. Of particular importance in the testimony of witness Defendant B was her admission that she had no dispute of any facts alleged by the state, which is the confession. I agree, all the facts are true. Defendant B declined to directly state her name and chose to identify herself as the authorized representative of Defendant B. Defendant B testified she was a secured party with respect to the medicine chests named in the state's petition. Those are the entities and the companies that are doing business on the internet. Defendant B couldn't recall if the medicine chests were a sole proprietorship or incorporated entities. Testify, 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 as though the facts are relevant. Defendant B denied knowing if she marked any pet medicines or foods, marketed any pet medicines or foods through the Medicine Chest website. Although she initially guessed she did have a website, she then didn't recall. When presented with pages downloaded from the Avian Medicine Chest website, which contained her picture and a claimed biography, she, quote, barely recalled, unquote, it. but conceded the picture, quote, looks a lot like defendant B, unquote. New paragraph. You see, once you don't know what you're doing and you get in trouble, it only keeps getting much worse from there. Witness defendant A testified in part that she had been an employee of defendant B and the medicine chest, but that she had left her position in October of 2002. Defendant B testified defendant A was terminated in October. New paragraph. The state's witness testified in part that the Farm Division of the Iowa Attorney General's office had registered with the defendant's website during the summer of 2002 so as to monitor whether the defendants were continuing to market pet medicines or foods via the internet after the court issued its temporary and preliminary injunctions that had said they better not. From the time of registration until this hearing, defendants had sent email marketing information to the registrant state on no less than 31 separate occasions, violating the order. The Attorney General's office had received complaints concerning the medicine chest from consumers in Arizona, Florida, and Illinois. New paragraph. Defendant A declined the opportunity to cross-examine the state's witness and called no witnesses. New paragraph. Defendant B cross-examined the state's witnesses and called the state's trial counsel as a witness. Is she arguing the merits of the case, maybe? Defendant B elicited testimony concerning the witness's address and the state's pretrial settlement proposal. The state's proposal included a payment by the defendant medicine chest in the amount of $25,000. A check signed by defendant B was tendered. However, the state determined the check was drawn on a closed account, so the proposed settlement was not accepted. New paragraph. Throughout the proceeding, the court had the opportunity to observe the conduct and demeanor of the parties and the witnesses. Defendant A declined the court's invitation to sit at counsel table next to defendant B and elected to stay seated in the spectator seating of the courtroom. The court concludes that defendant B was consistently evasive and disingenuous in her testimony, i.e., isn't she in dishonor of trying to help the court settle it? New paragraph. The court, having considered the record and the court file, now make these findings and orders. New paragraph. 1. Defendants B and A and the medicine chest were duly served with notices, copies of the state's petition, and copies of the court's order granting the state's request for a temporary restraining order as verified by affidavits of service served on the defendants May 1st, 2002 and filed with this court on May 1st, 2002. New paragraph. 2. None of the defendants appeared at the evidentiary hearing held on June 6, 2002 to consider the state's request for a preliminary injunction. Does that not mean that all the assumptions and presumptions must be true? And the court must apply them against the defendants since they have failed to appear and submit any other information? New paragraph. 3. At the June 6, 2002 preliminary injunction hearing, this court specifically found that the defendants made the following claims and assertions. New paragraph. A. Listen to the name of the products. That arthritis will rebuild good fiber in dog ligaments and joints. B. That animal fat found in raw hamburger helps lubricate dog joints. C. That commercial dog food is not wholesome, good, nutritional food. D. That drugs mask pet health problems, do not cure pet health problems and never prevent pet health problems. E. That hemotox will remove toxins from a dog's body. New paragraph. 4. None of the above claims and assertions is true. Did the court state where the evidence and facts to make that determination was placed in the court record? No. It's an assumption and a presumption. New paragraph. 5. The court entered an order granting preliminary injunctive relief on June 6, 2002, which order stated, in part, that the defendants were, quote, preliminarily enjoined from any further activity of any kind or nature associated with the marketing of any pet medicines or foods, unquote. New paragraph. 6. Since the entry of the June 6, 2002 order granting preliminary injunctive relief, defendants have made no attempts to obtain Federal Food and Drug Administration approval for any of its pet products as pet medicines, and the defendants remain in violation of the Food and Drug Administration animal drug laws. New paragraph. 7. Since the entry of the June 6, 2002 order granting preliminary injunctive relief, defendants have made no attempts to obtain Iowa Department of Agriculture and Land Stewardship approval for any of its pet medicines as pet food additives, and the defendants remain in violation of Iowa feed laws, period. New paragraph. 8. Since the entry of the June 6, 2002 order granting preliminary injunctive relief, defendants have continued to market pet medicines and food over the internet website, period. The court specifically finds that defendants have marketed their products by use of the internet no less than 31 separate occasions subsequent to the entry of the preliminary injunction herein, as evidenced by computer printouts of defendant's marketing information provided by the plaintiff, period. New paragraph. 9. Defendants have continued their operations as though no injunction was in place, period. New paragraph. 10. Defendant A was associated with Defendants B and the medicine chest until October 2002, but is no longer associated with the other defendants in this matter, period. New paragraph. Notice we have 10 findings. 10 is the law. It is therefore ordered that the defendants, comma, their successors, comma, assigns, comma, officers, comma, employees, comma, directors, comma, attorneys, comma, and other agents, comma, and all other persons or entities associated with them are permanently enjoined from any further activity of any kind or nature associated with the promotion, comma, marketing or sales of any pet medicines or foods, period. This permanent injunction shall remain in full force and effect until such time as, semicolon, new paragraph, A, each of the defendants has filed with this court documented compliance with the Food and Drug Administration rules and Iowa laws pertaining to pet medicines and pet food additives, semicolon, new paragraph, B, the defendants make application to and receive approval from this court to promote, comma, market or sell any of its pet medicines or foods, semicolon, and, new paragraph, C, all costs, comma, including investigative and court costs, comma, attorneys' fees and civil penalties hereinafter set forth are paid in full, period. Is this court violating anybody's rights? I don't think so. Is it going to keep defendant B from going into business? No, not as long as defendant B rebuts the presumptions or complies with the federal rules and regulations if in fact they are operating thereunder. That's all this has ever been about. Just be honorable to the public. Get your second witness. New paragraph. It is further ordered that defendant B, comma, individually in doing business as all those other entities, comma, shall be assessed the cost of this action and a civil penalty of $1,240,000, comma, said civil penalty representing the maximum penalty of $40,000 provided pursuant to Iowa Code Section 714.16 parentheses 7 per violation, comma, times each of 31 documented marketing emails sent in direct and intentional disregard of the preliminary injunction filed by the court on June 6, 2002, period. This civil penalty shall be payable to the Consumer Education Fund of the Office of the Iowa Attorney General, period. New paragraph. It is further ordered that Defendant B shall pay plaintiffs investigative costs and attorney's fees pursuant to Iowa Code Section 714.16, subparentheses 11, period. Plaintiff shall submit its statement of investigative costs and attorney's fees to the court not later than April 1st, 2003 for its approval. A copy of said statement shall be sent by regular mail to the defendants. New paragraph. It is further ordered that Defendant B shall pay interest on unpaid investigative costs, attorney's fees and civil penalties provided by law, period. New paragraph. It is further ordered that Defendant A shall be assessed a civil penalty of $5,000, payable to the Consumer Education Fund of the Iowa Attorney General, pursuant to Iowa Code Section 714.26, subparen 7, period. New paragraph. It is so ordered this 5th day of March, 2003, period, signed by the judge. So the order was issued on the 3rd month, which is completion of the church, on the 5th day, which is grace, in the year 20, which is redemption 03, dealing with the church. So she's lucky to have gotten off this lightly, because they're just doing their job. Now, that was the order which preceded a hearing to show cause why Defendant B should not be held in contempt of court. And here is the document that was filed on May 8, 2003, which came out of that hearing. Date: May 8, 2003. New paragraph. Defendant B appeared as ordered to show cause why she should not be held in contempt of court, period. Defendant B represented herself and denied the need of counsel. Why are you being dishonorable to the military court? Take whatever they want to offer you to help you out. So Defendant B represented herself, denied the need of counsel, and acknowledged the same on the record. There we go, testifying again. Defendant B testified and called witnesses in her behalf. B, you are going straight to jail, which is exactly what happened. Exhibits 1 through 10 were admitted by the court. Whatever you want to bring in. The first 6 exhibits offered by Defendant B and admitted. The court, having heard all the testimony, finds that Defendant B willfully violated the temporary, preliminary, and permanent restraining orders issued in the above case by continuing to do business through her various business names named as defendants in this matter while maintaining interest and control of those organizations, period. Further, she filed surety bonds and UCC filings involving Attorney General's office, court staff, district court judges, representatives of the Department of Agriculture without any basis in law and fact, and could provide no explanation or justification for these acts, period. New paragraph. Defendant B is held in willful contempt of this court and sentenced to 30 days in the county jail, period. Supplemental order will be issued dealing with the requested removal or expungement of UCC filings and surety bonds. Then it was signed by the judge, and he went on vacation. I guess with the $1,250,000 fine, he had made enough income for the county, and he was off to celebrate. Now, on June 9th, there was a supplemental order. And in that order, the judge expunged all the UCCs, the surety bonds, and et cetera, et cetera, et cetera. Okay? Now, what happened is our hero, Defendant B, got out of jail and called me up and said, got to do something. What should I be doing here? Now I said, gee, that's interesting. You got out of jail. You praying? Is that a good idea, Caleb? Okay, what you ought to be doing is praying vigorously. Much more than you have been. Okay. I said, you're out of jail. That's kind of interesting. How did you get out of jail? Well, my time was up. Going, well, gee, there's lots of stuff going on. Your time could be up, but how did that purge the contempt? And then she goes, well, my attorney filed some paperwork. And I'm going, okay, your attorney filed some paperwork. Well, yeah, some of my friends went and got this attorney, and the attorney filed some paperwork. And I'm going, okay. And her first question was, do you think I ought to get rid of my attorney now? And I'm saying to myself, God, she's out of jail. He's doing better than she's been doing. Maybe you don't want to get rid of your attorney. He's probably the only good thing you got going right now, But I didn't want to, burst her balloon. Maybe she loves jail food. Maybe it's better than pet medicine food. I don't know. So here it is, May 16th. Now remember, that was May, whatever it was, 8th. No, it was, this is the day a motion by that attorney was clocked in on May 16th. It was certainly a week or more after she was in jail. Okay? And the attorney filed a document styled Motion to Vacate or Modify Judgment. Okay? How do you purge a contempt? You either undo the contempt or you raise some form of rebuttal to a presumption which either brought on the contempt or allowed them to execute the contempt. It's that simple. So what do you think the attorney's going to do? He's going to argue.
Of course.
That's where he gets the big bucks. So he's not going to resolve an issue. He's going to go in and create an issue. Now, how do you think the attorney is going to get her out of jail? Let me ask you a question. Let's go back to the order I just read. You are Defendant B. Or else you're Defendant B with a lot more knowledge than what Defendant B has and what Defendant B has been doing. What would you do with that order? Accept it? What about the facts in that order? Every fact in that order was true. There was no fact that was not true in that order. So you accept every fact as true. Now, how are you going to defeat the contempt? You got to bring in some additional facts that is going to change the issue as to why should I or should I not be in jail. Now, attorneys aren't stupid. They're going to come in and argue, but basically they're going to be somewhere along that line. So is this attorney going to go in and say, my client's innocent, my client hasn't done those things? No, you can never prove that. It's set in stone. Defendant B has been dishonoring that court left and right. So what did the attorney for the new defendant B come in and argue? You guys have been violating your rules of procedure and you've illegally got her in jail. Beep, she gets out. Because we're going to argue some new facts. He brought in some extra facts which shows that two wrongs don't make a right, and you better get her out of there unless you can do it right. It's not what you said about her, it's the way you went about doing what you did. You didn't follow your own rules. Quoting a famous Hollywood movie, the rules are merely suggestions. That's true, but that's not for us to decide right now. If you want to come in and argue and start the game, we'll let her out so that we can start the game and play another round. So listen to what the attorney for defendant B does. Comes now defendant B by and through her attorney, pursuant to Rule 1.1013 of the Iowa Rules of Civil Procedure, and states, next paragraph, 1. On May 1, 2002, the state of Iowa filed a petition in equity herein, under Iowa Code Section 714.16, to enjoin certain activities by defendant B and others, period. New paragraph, 2. At the time of such filing, the state obtained an, quote, order granting temporary injunctive relief, unquote, parentheses, hereinafter, quote, first order, unquote, ending parentheses, against defendant B and others, period. New paragraph. 3. The first order was a temporary order without notice, as contemplated by Rule 1.1507 of the Iowa Rules of Civil Procedure, which requires applicant's attorney to certify certain matters concerning notice, semicolon. Further, said petition failed to provide such certificate as required, period. New paragraph. You guys are dotting your I's and crossing your T's. Shame, 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 shame on you. 4. Said first notice adopted findings of fact as alleged in the petition, which were prejudicial to defendant B, without allowing her a due process hearing or notice as contemplated by Rule 1.1507, period. New paragraph. 5. The petition filed herein, which provided the basis for the first order, failed to allege or provide evidence that defendant B's actions or continuance thereof gravely or irreparably injured the plaintiff or any other person or entity, as required by Rule 1.1502 subparen 1 of the Iowa Rules of Civil Procedure, period. What has the attorney just stated in his motion? They failed to state a claim. There's no damaged party. Now, before I go on, at least 80% of you in this room ought to understand what defendant B should be doing or must do to extract her bod from this predicament. What's going on here? What hasn't she done? Well, admitted she's wrong. She's not wrong. She hasn't accepted the facts. Yes, she says she accepts everything, returns everything. Well, she's presenting evidence, so yes, she's in the game even though she thinks she isn't, and she's doing everything backwards in dishonor and wrong. What is the substantive issue by the Attorney General of the state of Iowa? What is the unforgivable crime of Defendant B in this matter? No license? They're not talking about a license. The products are no good. They are not saying the products are no good. They're not approved. Nobody said the products had to be approved. There's a man that finally is starting to get somewhat close. What did you say again? Well, they are making a conclusion that her product advertised on the internet involves a medicine. Why would they assume that? The name of the pet foods all include the name of a medicine or a disease in the name of the food. What I ask this woman is, do any of your products contain any kind of a controlled substance? Medicine, drug, additive, anything? She answered, absolutely not. I ask her, is there any part of your product which comes under the scope of review by the Food and Drug Administration? She said, I asked them, and they said, well, we don't know, but I don't believe they do. I asked Defendant B, if they're purely pet food with no controlled, license restricted substances, does the provisions for the Food and Drug Administration require that you submit it for review? She said, I asked them and they said, we have no interest in it. I said, what about the Iowa Farm Group? No, likewise, they have no interest. I said to this woman, have you ever done a negative averment at any time, in this case, to anyone, suggesting that there is no controlled substance or medicines involved in any of these products? She said, I have not done that. She's got a $1.25 million fine with interest, not to mention the investigation charges and the interest and the fines and the fees, because she failed to do the very first thing we've been talking about, confession and avoidance. She jumped in and did all the confessions. She wouldn't cooperate and has done no avoidances. She failed to rebut a presumption. Now, she failed to rebut those presumptions, but why are they attacking her? What is the real problem? No, it is not complaints from the public. No, it is not dishonor. Medicine? What do you mean medicine?
Because she claims the title, medicine check.
Oh, the title to her company lists either a medicine or a disease. Don't you think those are copyrighted? to their licensed and regulated professions. So what is her real problem? Trademark copyright infringement. That's all this is about. The whole case is about the stupid name she chose for her products. That's why all these other issues are going nowhere.